Hi everyone, my name is Rasya.
My name is Rafli.
My name is Nayaka.
Today we are going to talk about change of status stay for me.
Moving to a new country bring exciting opportunities, and sometimes change in your life call for change in your stay permit. Whether you are starting school, beginning a new job, joining a family, or simply switching visa categories, changing your stay permit status is an important step.
Human mobility is a dynamic change in resident permit status, a common occurrence, especially for foreigners who enter initial with special initial purpose, but later face changing circumstances. A country policy on status adjustment reflects the flexibility of its legal system and its ability to adapt to the needs of the country.
However, this process is not without administrative challenge. Principle of selectivity and issue of fairness and access to legal research. According to Article 50 and 51 of Law Number 6 of 2011 on immigration, a change status can be reversed by fulfilling certain requirements such as providing a complete document, complying with legal regulation, and having no record of appeal. The application must be submitted to the immigration office and is assessed based on national interest and humanitarian consideration. For instance, in this case, a marriage between a foreign national and an Indonesian citizen, which allow for a status change to limited stay permit or ITAS on the ground of family unification. The change of resident permit status is closely linked to the right to family life and reunification. For foreigners who marry a citizen and choose to settle in a country, changing status from a visit visa to a family ITAS is not merely an administrative matter, but also concern a fundamental right to live together and a form of family. Therefore, regulation regarding status change should practice a humanistic approach that ensures the protection of the family. Of a family right rather than a really solely on a bureaucratic framework.
Law number 6 of 2011 on immigration provides as well considered mechanism for the change of residence permit status, including humanitarian aspects and national interests. However, in practice, there are still several challenges that prevent justice from being fully realized for all the groups of migrants. Some common obstacles include high costs and complex administrative, complicated legacy, and documentation dependence on local sponsors. Although the law formally establishes a fair procedure for status adjustment, ensuring equal treatment, equitable access, and protection of human rights. In reality, these principles have not been fully experienced by all migrant groups. Policy, reform, and improved implementation are necessary to ensure that the procedure is truly fair, inclusive, and oriented toward the protection of human rights, including the right to family unity.
Fundamental principle of the policy. First, justice and non-discrimination. Second, humanistic and family-oriented approach. And third, administrative efficiency. Key component of the policy. Family-based status adjustment pathway. Streamline and digitalization administrative process. Legal assistance and access to information. Clear processing timelines. An objection and appeal mechanism. Success indicator of the policy. Average processing time for status change less than 30 days.
increase in successful family-based cases, more than 25% per year, reduction in administrative complaint, more than 50% within 2 years, and user satisfaction with service, more than 80 satisfied or highly satisfied.
The presence of local sponsors in the immigration system can have a direct effect on the position of and both strength and weakening it. On one hand, local sponsor, whether individual or institution, can enhance a migrant position by providing access to legal residency, employment, and better social service. On the other hand, the reliance on local sponsor can potentially weaken migrant position, especially when the relationship is exploitative or imbalanced. Migrants who depend on sponsor for status change or progress. Renewals may become trapped in a state of dependency that increases their vulnerability, for example, in cases of marriage or family relationship. The sponsor may abuse their position, such as by withholding documents or threatening to withdraw support.
Status adjustment allows a state to determine who is eligible to stay longer or settle permanently based on various criteria such as economic capability, family relationships, or contributions to national interest. In this way, the state is able to select migrants who are deemed to meet certain standards such as skilled workers, investors, or legal spouse of citizens.
This process also functions as a tool of control and ensuring that migrants comply with immigration legislation, preventing misses or overstays, and monitoring the presence of foreign nationals within this territory. The state holds considerable discretion in acknowledging status adjustment application, often by consideration of security, public order, and social stability.
However, while this mechanism is designed to regulate migration and uphold national sovereignty, it can also create barriers for vulnerable migrants, such as those who don't meet strict administrative criteria or who in informal relationship, thereby reinforcing inequalities in access to the right to reside and form family. Therefore, regulation regarding status change should prioritize a humanistic approach that ensures the protection of family rights, rather than relying solely on a pure equality framework.
I hope you can get something from this video, and